Chapter 17 continues the work begun in Chapter 16 by addressing the sections of the Office Legal Memorandum that require the most sophisticated analytical skill: the analysis, conclusion, and recommendations. If Chapter 16 established the foundation, understanding the memo's purpose, completing the pre-writing stage, and drafting the opening sections, Chapter 17 builds the structure. The analysis section is where legal reasoning is fully developed. The conclusion section synthesizes that reasoning into a summary the reader can rely upon. The recommendation section, where included, translates the legal analysis into practical guidance for the supervising attorney. Together, these three sections represent the substantive core of the memo, the part that demonstrates the depth of research, the quality of analytical thinking, and the ability to apply law to facts in a clear, organized, and professional way. Chapter 17 also introduces the IRAC framework, which provides the organizational structure for legal analysis. IRAC, issue, rule, analysis, conclusion, is the universal analytical format used throughout legal practice from law school through professional work by attorneys, paralegals, and judges alike. The chapter case study, State versus Kent, involves a constructive possession question arising from a drug evidence scenario. That case will be used throughout the chapter to ground the analytical concepts in a concrete and realistic legal problem. The goal of this chapter is to equip students with the skills needed to draft a complete, professional, and analytically rigorous office legal memorandum. Chapter 17 is organized around three learning objectives, each of which builds directly on the prior chapter's foundation. The first objective is to understand the elements and format of the analysis, conclusion, and recommendation sections of an office legal memorandum. This means more than recognizing the names of these sections. It requires understanding what belongs in each one, in what order, and why. The second objective is to learn to draft each section with clarity and precision. Drafting skills are not developed by reading about writing. They are developed through practice, through working with examples, and through understanding the standards against which professional legal writing is measured. The third objective is to be able to explain the general considerations that govern professional legal writing. Legal writing has conventions that differ from academic or general professional writing, and understanding those conventions is essential to producing work product that meets the expectations of the legal workplace. These three objectives are cumulative. Understanding the format supports effective drafting, and effective drafting requires applying the broader writing principles. The chapter uses the State versus Kent case scenario to demonstrate each concept in a practical context, making it easier to see how abstract principles translate into actual memo language. By the end of the chapter, students should have the knowledge and framework needed to take a legal research assignment from the pre-writing stage all the way through to a completed professional memorandum ready for the supervising attorney's review. The case study for Chapter 17 is State versus Kent, a criminal matter involving the defendant Raj Swinton. Officers executed a search warrant on January 7th at a third-floor apartment. Upon entry, Swinton was handcuffed and moved to the kitchen while officers searched the bedroom. In the bedroom, officers discovered an 8-inch hole in the window. 3 floors below, in the common parking area beneath that window, officers found 1 ounce of rock cocaine. No fingerprints connected Swinton to the drugs. No witnesses placed Swinton at the window or observed him disposing of anything. The central legal question raised by these facts is whether Swinton can be charged with constructive possession of the cocaine found in the parking lot. Constructive possession is a legal doctrine that allows a defendant to be found in possession of contraband even when it is not physically on the defendant's person, provided the prosecution can establish that the defendant had both knowledge of the contraband and control over it. This case study is well chosen for illustrating the analysis section of the memo. The facts are specific, the legal question is clearly defined. There are significant evidentiary gaps that affect the analysis, and the outcome is genuinely uncertain, which makes it useful for demonstrating how to address counter-analysis and handle legal conclusions where certainty is not possible. Keep these facts in mind throughout the chapter as each component of the analysis section is introduced. The analysis section is the heart of the office legal memorandum. Every other section, the heading, the statement of assignment, the issue, the brief answer, and the facts, exists to frame and support the analysis. The analysis is where the actual legal work is displayed, where the applicable law is identified and presented, where case law is interpreted and explained, where the law is applied to the client's specific facts, and where opposing arguments are examined and addressed. The analysis section provides a legal analysis of the issue or issues in the case, presenting the law, analyzing it, and applying it to the client's facts. This description is deceptively straightforward. Executing it well requires a command of the applicable law, a clear understanding of the client's facts, the ability to reason through how the law and facts interact, and the discipline to address not only the arguments that favor the client, but also those that do not. The analysis section is always the longest and most detailed section of the memo. It is also the section most directly tied to the value of the document. A memo with a well-organized heading and a clear issue statement, but a weak analysis is not a useful professional document. The analysis is where research becomes reasoning, and reasoning becomes a product the supervising attorney can actually use to advise the client, plan strategy, and make decisions. Drafting it well is a central skill this chapter develops. IRAC is the foundational organizational framework for legal analysis, and it is the structure that governs the analysis section of the Office Memorandum. The acronym stands for Issue, Rule, Analysis, and Conclusion. Each element plays a distinct and necessary role. The issue is the legal question being analyzed, the same question identified in the issue section of the memo. Presenting it at the start of the analysis section orients the reader before the legal reasoning begins. The rule is the applicable rule of law. The statute, constitutional provision, regulation, or common law principle that governs the legal question. Identifying the correct rule is the foundational step of legal analysis. The entire analytical structure depends on it. The analysis is the application of the rule to the facts of the client's case. This is the most demanding component of IRAC. It requires working through how the rule interacts with the specific facts, what the rule requires or prohibits, whether the facts satisfy or fail to satisfy those requirements, and what arguments can be made on each side. The conclusion summarizes how the law applies and what result it produces in the client's situation. IRAC is used universally in legal practice. Law students learn it in their first year. Attorneys structure their briefs around it. Judges use it to frame opinions. For paralegals and law clerks, fluency with IRAC is not optional. It is the analytical language of the profession, and mastering it is fundamental to producing credible, professional legal work product. The analysis section of an office memorandum is organized into 4 distinct parts, each serving a specific analytical function. Part A is the rule of law. This is where the applicable statute, constitutional provision, or controlling legal principle is identified and presented. The rule establishes the legal standard against which the client's facts will be measured. Part B is case law interpretation. When the rule of law requires elaboration because its terms are broad, ambiguous, or novel in application, relevant cases that interpret the rule are presented here. Not every analysis requires extensive case law discussion, but when courts have defined key terms or applied the rule in analogous circumstances, those cases belong in Part B. Part C is the application. This is where the rule, as interpreted by the case law, is applied directly to the client's facts. The application connects the legal standard to the specific circumstances of the matter at hand and is the most analytically demanding part of the memo. Part D is the counter-analysis. Legal analysis is not complete until opposing arguments have been examined. The counter-analysis identifies the strongest arguments against the client's position, addresses any weaknesses in the analysis, and evaluates whether those opposing arguments can be rebutted. This four-part structure, rule, case law, application, counter-analysis, follows directly from the IRAC framework and ensures that the analysis section is complete, balanced, and professionally sound. Part A of the analysis section requires presenting the applicable rule of law in a clear, properly attributed, and contextualized way. Several specific requirements govern this presentation. The first requirement is to use introductory language. The rule should never be quoted or summarized without first identifying it, its source, title, and relevance to the issue. Beginning directly with the statutory quotation, without orienting the reader, leaves the legal framework unexplained. The introductory sentence or sentences tell the reader what law governs the issue before presenting what that law says. The example from the chapter illustrates this approach. The rule of law governing the sale of securities is Section 59-903 of the New Washington Commercial Code. The section provides that structure, identify, then present, is the correct approach for every rule of law introduction. The second requirement is to quote only the relevant portions of the statute or rule. Lengthy statutory provisions often contain subsections that have no bearing on the issue at hand. Quoting irrelevant portions wastes the reader's attention and clutters the analysis. The third requirement is to provide proper citations for every authority presented. The fourth is to present multiple rules if more than one legal standard applies. Some issues are governed by several interrelated provisions, a statute, a regulation, and a constitutional requirement, for example, and all applicable rules must be identified and presented before the analysis of their application can proceed. Together, these requirements ensure the rule of law section provides a reliable and professional foundation for everything that follows. Part B of the analysis section, the case law discussion, is not always required, but it is required more often than it might appear. Case law interpretation becomes necessary in several specific circumstances. The first is when the rule of law uses broadly stated or general terms without definition. Statutes frequently use terms like reasonable, substantial, or oppressive conduct without specifying what those terms mean in practice. Courts define these terms through their decisions, and that judicial interpretation is essential to understanding what the rule actually requires. The second circumstance is when the meaning of statutory language is genuinely ambiguous or subject to more than one reasonable interpretation. Where the text of the statute does not resolve the question, courts have interpreted it, and those interpretations must be located and applied. The third circumstance is when the rule is being applied to a new or unusual fact situation that differs from the paradigmatic cases the statute was designed to address. Even clear statutory language may produce uncertain results when applied to novel circumstances, and case law from analogous situations provides guidance. A critical practice alert applies here. Even when a rule appears clear on its face, a cursory check of case law should always be performed. Courts sometimes interpret statutes in ways that are not apparent from the plain text, and missing a special interpretation can undermine the entire analysis. The absence of relevant case law is itself a finding that belongs in the memo, not an assumption that justifies skipping the research. When case law is relevant to the analysis, it must be presented in a structured, consistent manner. A four-step process governs the presentation of each case. The first step is to provide the case name and full citation. The reader must be able to identify and locate the authority being discussed. The name and citation appear first and are properly formatted according to the applicable citation rules. The second step is to present the relevant facts of the case. The purpose of this step is not to give a comprehensive factual summary, but to present enough factual detail to demonstrate that the case is on point, that its circumstances are sufficiently similar to the client's situation to make the court's ruling relevant. This requires judgment. Too little factual context leaves the reader unable to evaluate the case's relevance. Too much detail shifts the memo toward a case brief format, which is not the appropriate document. The third step is to state the legal principle or rule the court applied or established in deciding the case. This is the holding, the rule that emerges from the decision and that will be applied to the client's facts. The fourth step is to briefly explain the court's rationale, the reasoning behind its decision. A sentence or two explaining why the court ruled as it did gives the reader context for evaluating the strength of the precedent and understanding how it might apply to similar but not identical fact situations. All four steps together ensure the case is presented in a way that is clear, relevant, and professionally useful. Understanding the difference between how cases are presented in a case brief and how they are presented in an office memorandum is essential to drafting the analysis section correctly. The two documents serve different purposes, and that difference directly affects how much case information is appropriate in each context. A case brief is a comprehensive document. It includes the full procedural history of the case, all relevant background facts, detailed reasoning from the opinion, the holding and disposition, and a comprehensive analysis of the court's legal reasoning. The case brief is a study tool. Its purpose is to enable thorough understanding of a single decision in all its detail. An office memorandum has a different purpose. It is a practical document designed to answer a specific legal question about a client's situation. When presenting a case in the memo, the goal is not to comprehensively document everything the court said and did. It is to present only what is necessary to demonstrate the case's relevance to the issue and to show how the court's rule applies to the client's facts. In the memo, this means presenting only the facts that show the case is on point, the applicable rule of law the case establishes, a brief explanation of the court's rationale, and the connection to the client's situation. Everything else, procedural, history, unrelated background, extended quotations from the opinion, belongs in a case brief, not a legal memo. Including unnecessary detail in the memo analysis slows the reader, obscures the relevant legal points, and reflects a misunderstanding of the document's function. Decisions about when and how to quote court language directly are important to drafting a professional analysis section. 3 principles govern effective use of quotations in office memoranda. The first principle is to quote court language when presenting the rule of law and key judicial reasoning. Direct quotations from a court's opinion carry authority that paraphrasing does not. When a court has stated a legal standard in specific language, particularly when that language is the actual test courts apply, quoting that language preserves its precision and gives the analysis maximum credibility. Paraphrasing a legal standard introduces the risk of inadvertently altering its meaning. The second principle is to avoid overquoting. A memo that consists primarily of extended block quotations from court opinions is not a legal analysis. It is a compilation of research. The memo writer's job is to analyze, not just to assemble. Quotations should support and ground the analysis, not substitute for it. If every paragraph is a quotation followed by a brief sentence of commentary, the analytical work has not been done. The third principle is to use pinpoint citations for every quotation. A pinpoint citation identifies not just the case, but the specific page of the opinion where the quoted language appears. This precision is required for professional legal citation practice and enables the reader to locate and verify the quoted material quickly. Together, these three principles produce a memo analysis that is authoritative, analytical, and precisely documented, reflecting the professional standard expected in legal practice. Part C of the analysis section, the application, is where the analytical work of the entire memo comes to its essential purpose. All of the preceding work, identifying the rule, locating and presenting the relevant case law, explaining the court's rationale, exists to make this step possible. The application is where the rule of law, as interpreted by the cases, is brought into direct contact with the client's specific facts to determine what result the law produces. When the rule is straightforward and its meaning is clear without case law elaboration, the application follows directly from the rule itself. The relevant facts are identified, measured against the legal standard, and the result is stated. When case law has been discussed in Part B, the application follows immediately after each case, connecting the principle the court established to the facts of the client's situation. This structural choice keeps the rule and its application proximate in the text, which makes the analysis easier to follow. Where the client's facts closely mirror the facts of the precedent case, the comparison is direct. The same conduct, the same circumstances, and therefore the same legal result. Where the facts differ, the analysis must address those differences honestly, explaining whether they are legally significant or whether the rule still applies despite the factual distinctions. One principle must be stated plainly. It is not acceptable to present the rule of law and the case law analysis and then fail to complete the application. The entire purpose of the memo analysis is to answer the legal question by applying the law to the facts. That step must always be completed. The application example from Chapter 17 illustrates how the case law and application steps work together in practice. The case involved is Cedric versus Ely, in which the court defined oppressive conduct as wrongful conduct that benefits the majority shareholders at the detriment of the minority. In that case, the court held that a majority shareholder who granted themselves a bonus exceeding triple their annual salary while simultaneously refusing to allow dividends had engaged in oppressive conduct meeting that definition. Having presented the case and the legal standard it established, the memo then moves immediately to the application. The application begins by connecting the client's facts directly to the Cedric standard. In the client's matter, just as in Cedric, the majority shareholder granted themselves bonuses exceeding triple their annual salary while refusing to allow dividends. The factual parallel is explicit and direct. The application then states the legal consequence. If the court follows the definition established in Cedric, the majority shareholder in the client's case engaged in oppressive conduct. Several features of this application are worth noting. The connection to the precedent case is made explicit. The phrase, just as in Cedric, signals the comparison. The key facts on both sides are identified. The conclusion is conditional. If the court follows, which is the appropriate hedging language for an office memo that is predicting how a court is likely to rule, rather than stating a certain outcome. This example demonstrates the concise, direct style that effective application paragraphs require. Part D of the analysis section, the counter-analysis, is the component that transforms a one-sided summary of favorable law into a genuine legal analysis. Legal analysis is not complete until opposing arguments have been identified, examined, and addressed. No legal position is without vulnerabilities, and the supervising attorney needs to know what those vulnerabilities are. The counter-analysis serves three functions. First, it requires anticipating the arguments the opposing side is likely to raise. This demands stepping outside the client's perspective and honestly considering the strongest version of the arguments against the client's position. Identifying weak counter-arguments while ignoring strong ones does not serve the attorney or the client. Second, the counter-analysis addresses weaknesses in the analysis itself, gaps in the evidence, ambiguous facts, unfavorable case law, or statutory language that cuts against the client. These weaknesses exist whether or not they are acknowledged, and they are better identified in the memo than discovered for the first time at trial. Third, the counter-analysis provides a rebuttal where one exists. After presenting the opposing argument, the analysis evaluates whether that argument is ultimately persuasive, whether it is distinguishable on the facts, whether it relies on minority authority, or whether it fails to account for controlling precedent. Placement of the counter-analysis matters. It belongs immediately after the application section, so that the reader can compare the primary analysis and the counter-arguments side by side without having to navigate across separate sections of the document. This proximity makes the full picture of the legal question clear. The conclusion section of the office legal memorandum serves a purpose distinct from the brief answer and from the analysis. Where the brief answer provides an immediate, upfront response to the issue before the analysis begins, the conclusion comes after the full analysis and synthesizes it into a compact summary. The conclusion's purpose is to give the reader, particularly a busy attorney who may return to the memo days or weeks after first reading it, a way to understand the essential legal analysis without rereading the entire document. The conclusion includes references to all enacted law discussed in the analysis, a summary of all case law presented, a brief statement of how the law applies to the client's facts, and the ultimate legal result. One firm rule governs the conclusion. No new information or new legal authorities may be introduced. The conclusion is a synthesis, not an extension of the analysis. Any authority or argument that appears in the conclusion must have been fully developed in the analysis section. If new information belongs somewhere, it belongs in the analysis, not dropped into the conclusion as an afterthought. The conclusion is typically shorter than the analysis section and requires fewer introductory and transitional sentences, because the reader has already worked through the full analysis and does not need the same level of contextual orientation. A well-drafted conclusion gives the reader confidence that the legal question has been thoroughly researched, carefully analyzed, and clearly resolved, or, where resolution is uncertain, honestly assessed. Understanding how to draft an effective conclusion is best illustrated through example. The chapter provides one that demonstrates the essential components in a compact, well-structured form. The example addresses a drug possession matter. The conclusion states, the applicable statute prohibits possession of proscribed drugs. The relevant case law establishes that constructive possession requires evidence of both knowledge and control. In the client's case, the record contains no evidence of either element. If the case law is followed, there is insufficient evidence to support a possession charge. That four-sentence conclusion accomplishes everything a conclusion is required to do. It references the applicable enacted law by identifying the specific statute. It summarizes the governing case law by stating the legal standard, knowledge and control, that constructive possession requires. It applies that standard to the client's facts by noting the absence of evidence on both elements, and it states the legal result, insufficient evidence to support the charge, conditionally but clearly. The conditional phrasing, if the case law is followed, is appropriate for an office memo. The conclusion is not a judicial ruling. It is a prediction and analysis. Using conditional language accurately reflects the nature of legal prediction without undermining the analytical conclusion. Achieving this level of concision requires that the analysis section do its full work first. The conclusion can be brief precisely because the analysis has already developed the reasoning in detail. The conclusion distills that reasoning to its essential elements. In complex memoranda involving multiple issues, a decision must be made about where to place the conclusion for each issue. Two approaches are available, and both are professionally acceptable depending on the circumstances. The first approach is to present a conclusion immediately following the analysis of each issue, before moving on to the next one. This structure keeps the legal question, its analysis, and its conclusion together as a single, self-contained unit. The reader does not have to hold the results of multiple analyses in mind simultaneously. Each issue is resolved before the next begins. This approach is particularly well suited to complex memos where the issues are lengthy or where the analysis of each issue runs to several pages. When issues are independent and the analysis of each is substantial, grouping the conclusion with its issue makes the memo more navigable. The second approach is to present a single consolidated conclusion at the end of the memo, after all issues have been analyzed. This structure works well when the memo addresses only two issues, and the analysis of each is not overly complex. When the reader can reasonably be expected to retain the analytical threads from both issues long enough to benefit from a unified conclusion. The best practice in all cases is to choose the format that best serves clarity and readability for the specific memo at hand. That choice depends on the number of issues, the length and complexity of each analysis, and the preferences of the supervising attorney. When in doubt, grouping the conclusion with its issue is the safer choice for readability. The recommendation section is the final component of the office legal memorandum. Not all law offices include it as a standard section, and not all supervising attorneys expect it. When it is included, however, it performs a function that no other section of the memo addresses. It translates the legal analysis into practical guidance about what should happen next. The recommendations section can address several distinct types of next steps. The first type is action recommendations, suggestions about what the supervising attorney should consider doing based on the legal analysis. If the analysis reveals that the client's position is legally strong, the recommendation might favor proceeding toward trial. If the analysis identifies significant weaknesses, it might recommend exploring settlement. The second type is additional factual investigation. Legal analysis is always dependent on the facts available at the time the memo is written, and those facts are sometimes incomplete. The recommendations section is the appropriate place to identify informational gaps. Missing witness interviews, documents not yet obtained, physical evidence not yet examined, that could affect the legal outcome. The third type is further legal research. If constraints on time or resources limited the scope of the research, that limitation should be noted, along with identification of the areas that warrant additional attention. The fourth type is identification of related legal issues that emerged during research, but were not within the scope of the original assignment. Additional causes of action, potential defenses, or related claims the attorney should be aware of. All of these contribute to the memo's usefulness as a practical, professional document. Several general writing considerations apply throughout the office: legal memorandum, and distinguish professional legal writing from other forms of written communication. 4 of these considerations deserve particular attention. The first is the use of headings. Headings provide structure, guide the reader through the document, and allow quick navigation to specific sections. In a longer or more complex memo, headings are essential to readability. They signal transitions between major analytical units and allow the busy attorney to locate a particular section without reading through the entire document sequentially. The second consideration is the use of introductory sentences. No section or subsection of the memo should begin abruptly with substantive content. Each topic should be introduced with a sentence or two that tells the reader what is to follow. Jumping directly into a statutory quotation without identifying the law, or beginning a case discussion without indicating what legal issue the case addresses, leaves the reader disoriented. Introductory sentences orient before informing. The third consideration is the use of transition sentences. When moving from the rule of law to the case law discussion or from one case to the next, a transition sentence explains the connection. Why this authority follows from what came before. Transitions maintain the analytical flow and prevent the memo from reading as a disconnected list of legal authorities. The fourth consideration is paragraph structure. Each distinct topic belongs in its own paragraph. Combining multiple subjects in a single paragraph creates confusion. A clearly structured paragraph addresses one point, develops it fully, and then concludes before the next topic begins. Legal analysis ideally relies on mandatory authority, the controlling statutes and case law of the jurisdiction where the client's matter will be decided. But mandatory authority is not always available. A legal question may arise in an area where the jurisdiction's courts have not yet ruled, where the applicable statute is new and uninterpreted, or where the question is genuinely novel. In those circumstances, persuasive precedent from other jurisdictions may be used, but its use requires proper foundation and explanation. Two specific requirements govern the use of persuasive authority in an office memo. The first is to explain why persuasive authority is being used. The reader should not have to wonder why the memo is citing cases from another state. The explanation might be that no controlling authority exists in the jurisdiction, that the out-of-state statute is identical to the applicable local statute, or that the cited jurisdiction's approach has been recognized as progressive and likely to be followed. Whatever the reason, it should be stated explicitly before the persuasive authority is presented. The second requirement is to lay a foundation that justifies reliance on the out-of-state authority. This means demonstrating the connection between the foreign jurisdiction and the forum jurisdiction, showing that the statutory language is the same, that the courts have cited the out-of-state authority approvingly, or that the legal framework is sufficiently similar that the foreign precedent is genuinely informative. Without this foundation, citing persuasive authority appears arbitrary and undermines the credibility of the analysis. Legal research does not always produce a clear, definitive answer. Statutes are sometimes ambiguous. Court decisions on a given question may be few, divided, or from non-controlling jurisdictions. The facts of a client's situation may differ from the facts of available precedent in ways that make the outcome genuinely uncertain. Acknowledging this reality is not a failure of analysis. It is a reflection of the actual state of the law, and it is what objectivity requires. Several principles guide memo writing when definitive answers are unavailable. The first is to present the conclusions that the research and analysis support even when those conclusions are conditional. A conclusion that states, if the court adopts the majority rule, the likely outcome is X, but if the court follows the minority approach, the outcome may differ, is analytically sound and professionally appropriate. The second is to explain the source of the uncertainty. Is it a lack of directly applicable precedent, conflicting authority within the jurisdiction, an unresolved ambiguity in the statutory text, factual gaps that could determine the outcome either way? Identifying the specific source of uncertainty helps the attorney evaluate how much weight to give the analysis and what additional steps might reduce it. The third is to provide useful guidance despite the uncertainty. An attorney who receives a memo that simply says the law is unclear has not been well served. The memo should provide the best reasoned analysis possible given available authority, even where certainty is not achievable. Clarity about uncertainty is itself a form of professional competence. The revision process is an essential and non-negotiable component of professional legal writing. No memo, regardless of the writer's experience or skill level, is produced in a single draft. Legal writing requires multiple passes, each serving a distinct purpose, and the final product reflects the cumulative improvement of that iterative process. The first principle of revision is to approach the initial draft without the goal of perfection. The first draft is a tool for capturing research, analysis, and reasoning in written form. Attempting to make the first draft polished and final simultaneously tends to produce writing that is hesitant, overqualified, and slow to develop. The appropriate goal for the first draft is completeness, getting all of the analysis on the page in rough form so that there is material to work with. The second principle is to expect multiple revision passes. Each pass serves a different purpose. One pass evaluates the analytical structure, whether the argument flows logically, whether all components of IRAC are present, whether the application is complete. Another pass evaluates the writing itself, sentence clarity, paragraph structure, transitions, and precision of language. A final pass reviews citations, formatting, and the mechanical elements of the document. The third principle is that revision is more efficient than attempting to perfect the first draft. It is substantially faster and more effective to write a complete rough draft and then improve it than to proceed slowly through a single draft, attempting to produce polished sentences one at a time. The goal is a final product that is organized, analytically complete, error-free, and professionally presented. A consolidated checklist of key points provides a useful reference for ensuring that a completed office legal memorandum meets the professional standard required for legal practice. The first point is to follow the standard analytical format: rule of law, case law interpretation where needed, application to facts, and counter-analysis. The IRAC framework governs the structure, and all four components must be present and complete. The second point is to maintain the distinction between how cases are presented in a memo and how they are presented in a case brief. The memo includes only what is necessary to demonstrate relevance and support the application, not comprehensive procedural history or detailed recitation of every aspect of the court's reasoning. The third point is to always complete the application. Every analysis must include the step of applying the rule to the client's facts. Identifying the law and discussing the cases without connecting them to the client's situation leaves the analytical work unfinished. The fourth point is to always conduct the counter-analysis. Even when the counter-arguments are weak, they must be identified, presented, and addressed. A memo that only presents the favorable side of the analysis does not meet the objectivity standard the office memorandum requires. The fifth point is to ensure the conclusion is comprehensive. The conclusion must reference all applicable enacted law and all case law discussed in the analysis, and it must include a brief statement of how the law applies to the client's facts. No new authorities may be introduced in the conclusion for the first time. Here is a visual overview of the complete office legal memorandum structure, from heading through conclusion. This overview serves as a reference map for the document as a whole and reinforces the relationship between the sections covered in chapters 16 and 17. The full memo structure begins with the heading, which identifies the document, the parties, and the subject. It proceeds to the statement of assignment, which establishes the scope of the research. The issue follows, presenting the precise legal question with the applicable law and key facts incorporated. The brief answer provides an upfront, direct response to the issue. The statement of facts supplies the factual context for the analysis. The analysis section, the document's core, develops the full legal reasoning through the rule of law, case law interpretation, application to facts, and counter-analysis. The conclusion synthesizes the analysis into a compact summary of all applicable law and its application to the client situation. The recommendations section, where included, translates the legal conclusion into practical guidance for the next steps in the matter. Seeing the complete structure in one view makes clear how each section relates to the others, and how the memo functions as a single, integrated analytical document rather than a collection of separate components. The issue frames the analysis. The facts ground it. The analysis develops it. The conclusion distills it. The recommendations apply it. Each section is necessary, Each contributes a distinct function, and together they produce the professional legal memorandum that attorneys rely on to serve their clients competently. Chapter 17 completes the two-chapter treatment of the Office Legal Memorandum by providing the analytical and drafting skills needed to produce a professionally complete document. 3 foundational principles summarize the chapter's content. First, understanding the elements and format of the analysis, conclusion, and recommendations sections is not simply an academic exercise. It is the practical prerequisite for every legal memo assignment in professional practice. The IRAC framework, the 4-part analysis structure, and the requirements for the conclusion and recommendation sections are the tools of the trade. Second, drafting each section with clarity and precision requires both knowledge of the standards and repeated practice applying them. The examples in this chapter: the constructive possession scenario in State versus Kent, the oppressive conduct application in Cedric versus Ely, the concise conclusion model, provide concrete reference points for what professional drafting looks like in practice. Third, applying the general writing considerations, headings, introductory sentences, transition sentences, and clear paragraph structure is what separates a memo that contains the right information from a memo that communicates it effectively. The goal of every office memorandum is not merely to report research, but to analyze it, apply it, and present the results in a way the supervising attorney can use immediately and confidently. Mastering the analysis, conclusion, and recommendation sections, grounded in the IRAC framework and guided by the writing principles introduced in this chapter, is how that goal is achieved. These are the skills that define professional legal writing competence.